Welcome to Part 2 of the Residential Purchase Agreement put out by the California Association of Realtors. So we're starting here on paragraph number 4, which is called Allocation of Costs. And this is an important paragraph because it specifies which party to the contract is going to be responsible for which cost. So as you can see up here, it says, unless otherwise specified in writing, this paragraph only determines who is to pay for the inspection, test, or service. It does not determine who is going to pay for the work. So this is key. This is all about the inspections, disclosures, and reports. This does not predetermine what happens if we discover that something is needed to be corrected. That tends to be something that is negotiated later on during the transaction. So Section A is about the inspections and reports, and in this sample case we've checked that the seller shall pay for an inspection and report for wood-destroying pests and organisms, otherwise commonly known as termites, prepared by, and then in this case we've put Sue's Termite Company, a registered structural pest control company. Now, quite often I go ahead and fill this out, but I also add what's called the Wood Pest Addendum, and that's the WPA, and that's another contract that goes into a little bit more detail because this, as we said here, this only is about the report, but when it comes to termites, there's usually two different kinds of types of repairs that need to be done, so that gets handled in an addendum. In 4A2, if there is a septic system or a private sewage disposal system, you would want to check who is going to pay for that to be pumped and inspected. In this case, there is no septic, although here in the Palos Verdes Peninsula, we do have quite a few septic systems. So this is something that's important to ask your realtor. Number 3, the buyer and seller buyer or seller shall pay to have domestic wells tested. Again, in our area, there's not a lot of domestic wells, so this is commonly not used. So as you can see, we only check those things that apply. In paragraph 4, who is going to pay for the natural hazard zone disclosure report? And this is a mandatory disclosure that needs to happen. Actually, I don't know if it's mandatory, but it is something that's commonly done. This is going to tell you whether or not you are in a high fire zone, whether you're within a certain part of an earthquake fault or other types of natural hazards. So in this case, we've mentioned that the seller is going to pay for the NHD, and again, we just put in the name of the company that we want to use. For number 5, the seller shall pay for the following inspection or report. And in this case, we wrote city report and water cert or water certification. Depending on which community you're in here in Southern California, different cities have different requirements. Some cities do have a city report, some don't. This often has to do with code compliance and zoning and whether or not a property or a structure has been properly permitted. So again, you need to speak with your realtor, find out if there is a city report for the city that this property is located in and whether or not there's some sort of a water certification. So again, in our area, there are several cities that have both a city report and a water cert, and for this example, we want the seller to pay for those. Although this is not required, I do typically put in that the buyer is responsible to pay for a physical inspection. A physical inspection is not a mandatory requirement, but is highly, highly, highly recommended. I recommend it to all of my buyers. And this just makes it clear that the buyer has to pay for that. Usually a seller is not going to pay for that, although if they do have a physical inspection done ahead of time, they may provide that as part of their disclosures. For 4B, this is about government requirements and retrofits. So here in California, we need to have smoke detectors installed per the California Civil Code, and water heaters need to be braced. And then if there's any other minimum mandatory retrofits, such as earthquake shutoff valves or the new law requiring carbon monoxide detectors, we're asking the seller to pay for the cost of compliance with those. For 4C, this is talking about escrow and title and who's going to handle it. And typically in our area, buyers and sellers each pay their own escrow fee. So there's sort of an escrow fee for the seller and an escrow fee for the buyer, and they each pay their own. And the escrow holder in this case shall be Joe's Escrow Company. And again, the buyer can specify their escrow company, but quite often in our area, the seller has already started to work with an escrow company at the beginning. They've already started to gather necessary documents. So quite often the seller is going to request their escrow company. For 4C2, There's two, if this property is being financed, there are two different title insurance policies that are needed. One for the transition from the seller to the buyer and one for the buyer to the lender. So typically the buyer will pay for the one from the buyer to the lender and the seller will pay for the one from the seller to the buyer. So in this case, this is specifying the one from the seller to the buyer. And if there is no financing, of course, there is no second title policy, just the one from the seller to the buyer. For 4D, these are other costs that could come up in the transaction. Here in Los Angeles County, we do have a county transfer tax. So in this case, we're asking the seller to pay for that. In certain cities, such as the city of Redondo Beach, there is also a city transfer tax. So in this case, we've asked the seller to pay for that as well. And if there's a homeowners association, we have asked in this example the seller to pay any transfer fees and any document preparation fees. In some communities, there may be another private transfer fee. In this case, there isn't, but if there is, again, that might be specified here. And then if the buyer is requesting the seller to provide a warranty, then the seller, in this case, is going to pay the cost, usually not to exceed, it depends on the type of property, could be $250, $500, you want to know that up front, of a 1-year home warranty plan issued by a specific company, and then you might put any optional upgrades or other information that you want. And then there's room down here towards the bottom for the buyer and seller to specify any other type of cost that is known. And again, you're going to have the buyer is going to initial here, and eventually the seller is going to initial here. Moving on to page 3 of the contract, once again, you can see the property addresses at the top and the date that the contract was created. Paragraph 5 talks about closing and possession. The buyer intends or does not intend, in this case, to occupy the property as the buyer's primary residence. So the default in this case is that the buyer does intend to occupy the property. 5B, if the property is either seller occupied or vacant, this paragraph talks about when possession is going to transfer, and the default is possession is being transferred to the buyer at 5 p.m. on the date of the close of escrow. And again, there's other options here that we can check to change that. If transfer of title and possession do not occur at the same time, the buyer and the seller are advised to enter into a written occupancy agreement. So this would be in the case of a seller leaseback or a buyer early possession, and that has legal and insurance and tax implications. So you want to do that in writing, and you do want to consult with your insurance company and some legal advisors. Paragraph 5C, if this property is tenant occupied, then usually we want the property to be vacant at least 5 days prior to close of escrow, unless otherwise agreed in writing. If you do close escrow with a tenant in possession, the tenant does become the tenant of the new owner, and it can be complicated to have that tenant leave if you prefer. And again, a notice to the seller, if you cannot deliver the property vacant because of rent control or other laws, you may be in breach of this agreement. And again, or if you're purchasing an investment property or a property that you want the tenant to keep occupying, you can check that the tenant is going to remain in possession, in which case you want to possibly include this purchase agreement addendum form that they talk about here. Paragraph 5D, at the close of escrow, the seller is giving any warranty rights that are assignable and any copies of warranties. This will be typically for things like appliances, water heaters, any type of item that might come with the house but have a warranty. And at 5E, at the close of escrow, unless otherwise agreed in writing, the seller shall provide the keys and the means to operate all the locks, mailboxes, security systems, etc. So again, it's all about making sure that the buyer is able to use all the features of the property at close of escrow. This next paragraph, paragraph 6, has to do with statutory disclosures. These are disclosures that are required by law. So by law, the seller has to provide a federal lead-based paint disclosure if required, and that's going to be required on properties built prior to 1978. Also, the seller is required to provide a real estate transfer disclosure statement, which will be another video that I post. But if the seller's in possession, this talks about all kinds of things that the seller should know about the property. Again, federally mandated natural hazard disclosure statement, notice or actual knowledge or release of illegal controlled substances, Any notices of special tax or assessments or Melrose items or Bond Act items. This is any fines or assessments that might be on the property. And if the seller has actual knowledge of industrial use and military ordnance. These are all required to be disclosed either by federal or state law. Paragraph 6A2. The buyer then has a specific amount of time to return signed copies saying that they received those disclosures and that the seller has complied with the law. In 6A3, if the seller becomes aware prior to close of escrow of any adverse conditions material affecting the property or any inaccuracies in disclosures or representations that are provided, the seller must provide rapidly, promptly, a subsequent or amended disclosure or notice in writing. So if the seller discovers something, that all of a sudden a rain comes and the roof starts to leak, the seller is required to provide in writing that information because it would be an adverse condition that materially affects the property. But if the buyer is already aware of these things, like it becomes disclosed in a physical inspection report, then the seller is not required to give an amended disclosure. 6A4, if the seller does have to give or does give a subsequent or amended disclosure, then the buyer has the right to cancel within 3 days after delivery in person or 5 days after delivery by mail. And this is even after the contingency period is expired. So if you get 20, 25, 30 days into the transaction, the buyer has waived their contingencies, and yet a new disclosure is then now handed to them. They have 3 days for delivery in person or 5 days after delivery by mail to cancel the contract. And 6A5, this is just important to know, you cannot waive statutory and lead disclosures. That's prohibited by law. You cannot waive them. 6B, natural environmental hazards. Again, within a specific amount of time that is talked about later in the contract, the seller shall, if required, deliver the Earthquake Guide and Combined Hazards booklet provided by the California Association of Realtors, even if they're exempt to provide the Natural Hazard Zone Disclosure Report. For example, sometimes a bank-owned property, they do have to disclose if it's in certain zones. So even if they don't have to provide the big NHD, they do have to disclose if it's in certain types of zones, such as a special flood hazard, potential flooding area, very high fire hazard zone, or other types, and provide any information required. For 6C, within the time specified, in order to avoid withholding, the seller has to deliver an affidavit that complies with the federal and California withholding laws. So basically, if the seller does not give this information to the buyer, then the buyer has to withhold taxes from the property. For 6D down here, this is Megan's Law, and Megan's Law is a disclosure about registered sex offenders. So there is a website where you can go on and check for registered sex offenders. Paragraph number 7, if this is a condominium or a planned development, the seller has 7, or again, if checked to change it, days after acceptance to disclose whether the property is a condominium or a planned development or other sort of common interest subdivision, sometimes also known if it's a member of a homeowners association. And if it is, the seller has 3 days, or again, you can change that, to request from the homeowners association copies of any required documents, disclosures of any litigation or pending litigation or claims against the homeowners association, a statement with the location and number of parking and storage spaces, and copies of the most recent 12 months of board minutes, HOA minutes for regular and special meetings, as well as names and contact information for of all the homeowners association that governs the property, including CC&Rs, and stuff like that. We're going to continue in part 3 of the residential purchase agreement.